And you need to let the court know whether or not you've reached an agreement with the state. If you have not, then it's going to jury trial.
How could I negotiate about a cop out to something that I'm just hearing for the...
Set your notifications to all. Let's roll, nerds.
Hello.
How you doing?
Oh, I'm doing okay. How are you doing?
Not so good.
Oh,
Judge.
well, I'm sorry to hear about that.
It's all right.
All right, so
We've been here a few times to propose a counter offer. We were partially successful in proposing it. Without going into the details of the offer, Mr. Simmons can't accept it currently. He's asked for some additional time. He's from another state, so he has some...
All right, pause right here. This opening sets the tone loud and clear. Texas courts are not here for excuses, travel issues, or emotional appeals. When a judge says plea deadline, that's not a suggestion, it's a countdown clock. Miss it, and your leverage disappears. Question for you watching. If you were facing jail time in another state, would you gamble on delay or lock in certainty early?
yes.
requested to pull the file. Mr. Simmons didn't know he had court today. He's present now.
Okay.
I-
All right. Just have them. Oh, Lamar Simmons.
And Your Honor, we had a pre-indictment court setting in August in about 2 weeks. And that was canceled because of the indictment.
Okay.
We had a sudden setting. His bond company didn't notify him to be here. I called A Action. They got him here.
All
That's why he wasn't here at 9 o'clock.
All right, thank you. All right, Ms. Ferguson.
Yes, ma'am.
On this case, if you'll set it for discovery, please.
Yes, ma'am. You want 30 days?
Yes.
I can do the August 28th. Judge.
All right, August 28th.
Thank you, Judge.
And state if you'll be prepared at that time to tender an offer.
Yes, Judge. And Your Honor, I know that I had reviewed some videos. I need to double check if, I know that we have a discovery setting, but I may need to get with the state about one specific video, verify whether we have it or not.
Okay. All right, thank you. Thank you for getting here. Once you sign the reset form, you're
Going to consider, and I know that Duffy's gone. I talked with Lauren. Lauren stepped out. But Lauren's going to reach out to the complaining witness. Lauren is going to see if she will make a revised offer. I proposed a counter offer. And Lauren needs about 2 weeks to contact the CWC if they're okay with a proposed offer.
all right, Norma, on this case, final plea deadline date, 3 weeks, please.
December 18th. Yeah, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Exactly. I say a day shy of a month, maybe. And then I reset it again for the 23rd, which is today. So today is the day. Either you've worked out an agreement with the state or you have not. If you have not worked out an agreement, then this is being set for jury trial. And the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court.
This is, can I speak now?
Yes.
What I'm saying is, well, my understanding of this was when I first gave me an offer, it was just throwing at me. But then the next offer, it wasn't off. I had offered today was something that I wasn't heard of to today. The last two offers was jail time.
No. Here's the thing. I'm not allowed to hear what the offers were. This is what I can tell you. Sometimes offers will change because maybe the defense attorney may talk to the state, and then the state may see things a different way, and they may say, that first offer that I made really wasn't just. Defense has come to me and told me reasons why the offer should be
This
something
is a
else.
critical procedural moment. The judge is formally setting a final plea deadline, which means negotiations are officially on borrowed time. From here on out, every delay hurts the defense, not the state. Prosecutors lose nothing by waiting. Defendants lose options. This is where courtroom patience quietly turns into courtroom pressure. And notice, no emotion, no theatrics, just process.
Are you available this afternoon?
Excluding the 1:30, the 175th doesn't have docket till 1:30. I'm set there for 2 people, but I'll be here this afternoon.
All right. So, well, I tell you what, you have till 11 o'clock to let the court know. Is that good for you, counsel?
Perhaps Afternoon would be best.
All right. So how long is it going to take you in the other court in the afternoon?
That I'm not certain, but I would hope to be here, hopefully prior to 2:30.
All right. So you're going to need to be back here at 2 p.m. And you need to let the court know whether or not you've reached an agreement with the state. If you have not, then it's going to jury trial.
How could I negotiate about a cop out to something that I'm just hearing for the first time? Every time when I come to court, outside of court, I'm supposed to have contact with my public defenders discussing this case.
All right. So
I'm just hearing it every time I come to court. That's when I talk to my public defender.
all right.
Your Honor,
It was like kind of shock or surprise to me. That's what I'm saying.
the offer that was made July 29th, I had explained to him that I was proposing a counter, that I explained what the counter was, what the counter would entail.
Mhm.
And I was successful in proposing that, except there's
Here's the legal reality check. The court is saying you've had time, you've had counsel, the window is closing. Judges don't want to hear about surprise offers once deadlines pass, because deadlines protect the system, not just the parties. This is the moment where hesitation turns into consequence. And if you're wondering who's winning this exchange right now, it's not the defendant.
Simmons.
Good afternoon, Judge.
Good afternoon.
I start with Mr. Simmons. We have accepted a plea offer. However, it would require time, but without discussing the offer, but it would be if you follow the agreement under special provision of the penal code. So the issue is that he has a litter of puppies. He has 8 puppies, 2 adult dogs. So it's 8 dogs he needs to go home and care for them. He doesn't have to pay. He would have to do time at the county jail. So he would have to make sure that payments were made in advance for rent. Initially, he was asking to come by tomorrow possibly, but he was asking for maybe a couple more days. And I've already talked with Lauren from the state, and she's okay with at least for tomorrow. But we have an agreement. The offer's open.
All right. So are you okay with bringing it back on Thursday? All right. So you're going to come back on Thursday. On Thursday, there will be no further continuances. Do you understand? All right, Norma, if you can recall this for disposition on Thursday, please.
And may you specify this Thursday or next week Thursday?
No. Oh, I'm so sorry. I just said Thursday. No, it's Thursday, the 25th.
This 25th?
Yes.
Yes. Okay.
Yes.
Yes, Judge.
All right. Once he signs the reset form, he's excused.
Thank you, Judge.
All right. Thank you.
Oh.
Yes, we will go into custody on the 25th.
06994, State versus Lamar Simmons. Can I have parties announced?
For the state?
The attorney of record is Joanna Hoyos. Joseph Stateson covering for Joanna Hoyos. She is on vacation.
All right. Do you have any objections to this attorney standing in for Joanne?
Ah, yes, the puppy plea. Emotionally compelling, legally irrelevant. Courts sentence people, not pets. While the judge may allow logistical flexibility, mitigation only goes so far when the charge is a state jail felony. This is where reality sets in. Responsibility doesn't pause because life is inconvenient. And once again, the message is clear. Texas doesn't negotiate with sympathy alone, especially under Judge Boyd.
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes.
You're charged with an unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you any defenses to this offense?
He has, we've discussed it, and we feel comfortable going forward today.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Simmons, has anyone threatened you, coerced you, placed you in fear, or forced you to enter this plea?
No,
Has anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yeah,
Did you understand if you're not a U.S. citizen, by entering this plea, you can be deported, not allowed to re-enter the United States, and denied naturalization?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail under 1244. There's a $700 fine and no applications. Did you understand that to be the plea?
yes,
Defense, is that the plea?
Yes, Your Honor. If I may add something at the appropriate time.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
None.
Then to the offense as charged, how do you plea?
guilty.
State
No
any,
contest.
Your Honor,
No
I'm sorry.
contest.
Yes, no contest, Your Honor.
all right, state any evidence?
Yes, Your Honor. Offer states Exhibit 1 and all attachments.
No objection.
Did you, state, you may be excused.
Okay.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same.
Very customary for judges to order that. I was hoping that you could order it and have it reflected on the plea bargain page or on the judgment. He has 10 actual days, spread it for all 10 days. And I told him that you're not authorized to give 2-for-1 credit. I know that the jail has their own policy. That's up to the jail for any calculations. But we ask that you follow the 60-day agreement. You don't go outside that, and all credit for time served and time money run concurrent.
All right, the court will, as previously stated, the court is going to follow your agreement. The court will sentence you to 60 days in the Bexar County Jail under 1244. There is a $700 fine, time and money to run concurrent, and court will give you credit for any time served. And so if you have 10 days credit, you'll receive 10 days credit. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Mhm.
All right, so what I can tell, we're off the record. So what I can tell you is the clerks will put into the system the number of days that you're to receive credit for. And as your attorney told you, I'm not responsible, or I can't make the sheriff's department give you 2-for-1 or 3-for-1. That's completely up to them. What I can tell you is, in subtracting the 10 days that you've already served, the most you will serve is 50 days. Do you understand?
yeah, so the 2-for-1,
jail.
right?
Well, the jail will calculate that.
What I can tell you is normally at the jail, if you're in general population and you do not cause any issues, you automatically receive 2 days for every day you serve. If you become a trustee, then you receive 3 days for every day that you serve.
Thank you.
Thank you, Judge.
Thank you.